petition. And in that petition, we have basically argued that basically the board cannot hear this matter because the board has already decided Mr. Jenkins' fate. And also, now there's an additional issue with regard to Mr. Jenkins. Not only has Mr. Jenkins sued the board members, but they have all been served. And if they have been served by a lawsuit, I don't think they can be impartial. Also, so I think that they can't have a hearing anyway, and they put themselves in that position. And I think if you look at the amendments to the petition, you will see where they have made statements that, hey, they've already terminated. And also in Exhibit 22 to my amendment, I have an article from the local paper here, and these three people are on an email list with the editor of the TNC, I think, where he put Mr. Jenkins dodged the bullet. Yeah. And you'll see it. And the reason Mr. Jenkins dodged the bullet is because they were going to fire him. Everybody knows that. Also, one of the things why I'm like, I am actually looking for something, and I'm actually looking for a copy of Mr. Jenkins' contract, which I do have. I think if you look at Mr. Jenkins' contract, it makes the procedures in 940 applicable. Not only does it make the procedures in 940 applicable, it says that Mr. Jenkins can only be terminated by just cause. And also, it says that any complaints against Mr. Jenkins must be given to Mr. Jenkins, and he's given an opportunity to investigate those complaints before they can be used as evidence in a termination. The other issue is the issue of subpoena. In this case, Mr. Jenkins does not have the right to subpoena because the chairperson has the authority to issue the subpoena. Okay? So he has no basis upon which to get the subpoena. And one thing the court needs to understand, that the laws that gave the power to the chairman, they basically came in effect around 1988, 1989, and we attached it to the Cleveland. And the reason they came in effect then is, you know, that at that time, Randolph County, Georgia School Board had a white superintendent, and the board chairman was white. And that's around the time you have the redistricting lawsuits where more blacks were coming on the boards of education. So what happened is these policies were put in place to maintain white control. The only problem with the policies now is that the board chairman happens to be black and the superintendent is black now. So I guess the argument from the respondents is that these policies are wrong. My only question is they're wrong in 2009? Were they wrong when they were implemented in 1988? I mean, Mr. Cook hasn't done anything wrong. All he has done was file policies that were in place. I don't think Mr. Cook came on the Board of Education until 1993-94. So these policies were already in place. And also in our amendment with regard to Mr. Jenkins, the court will see where all of these defendants have basically sent sent complaints to the Georgia Department of Education and the Professional Standards, Commission. They're acting in concert with them, but they want to now use the complaint to say, hey, we're going to terminate your contract. I might be wrong, Your Honor, but I don't think, as I know the law, under no set of circumstances will these three people be able to hear a termination hearing on Mr. Jenkins. And if they hear one, to me that's something that would be reversed, and I don't know why they would put themselves in that situation. That's all I have.